Start. Para. The accused is facing trial for offence punishable under section 7, 13 in bracket 1 another bracket D, read with 13 in bracket 2 of the Prevention of Corruption Act. The prosecution case in nutshell that the complainant Uddhav had jointly purchased agricultural field bearing gut number 457 area along with one Bhausaheb on 23/11/2012. The accused was working as circle officer of that area. After purchase, the complainant made various requests to the accused to make entries of the sale deed in the revenue record. The accused demanded rupees 16,000 for the same. Accordingly, the complainant paid the amount to the accused. However, the accused did not make necessary entries in the revenue record. Therefore, the complainant could not get Satbara extract reflecting his name. Thereafter, the complainant again made request to the accused for making entry in the revenue record. At that time, the accused demanded rupees 5,000 from him. As the accused had already accepted rupees 16,000, the compliant was not willing to pay further amount of rupees 5,000. Therefore, he made complaint with the Anti-Corruption Bureau, Ahmednagar on 17/7/2014. After verification of his complaint, the officers from Anti-Corruption Bureau, Ahmednagar laid pre-trap for verification of demand and thereafter laid a trap. The accused allegedly found while accepting the bribe of rupees 5,000. Therefore, the FIR came to be registered against him by the then Police Inspector, Anti-Corruption Bureau, Sri Rajendra, for the offence punishable under section 7(13) in bracket 1 another bracket D, read with 13 in bracket 2 of the Prevention of Corruption Act. Para. Not only the acceptance is doubtful, but interestingly, there is no script of the conversation during pre-trap Panchanama, that is Panchanama for confirmation of demand, nor there is any script for the conversation during the allegedly successful trap. If the evidence of the Pancha witness at the end of paragraph 3 would perused, it has mentioned that the script of conversation recorded by the vice recorder was prepared. It has also further mentioned in said paragraph that the memory card containing the voice recording of verification of demand was tried to be open in the laptop of the court, and the voice file was played in the open court by my learned predecessor. However, there was a conversation in respect of alleged acceptance of amount and not demand. Para. It is specific defense of the accused that there was no demand. Rather, he was telling the accused that he could not effect the mutation entry during the court order. Moreover, there is no voice recording in respect of confirmation of demand. Therefore, again on 16/5/2023, all three memory cards in connection with present case came to be brought in open court, and voice files therein came to be played. Admittedly, one of the card was containing voice sample of the accused. However, strangely, both the remaining cards were containing files of recording about alleged acceptance of amount, though the file names were different and their duration were different. Both the files were having same conversation about so-called acceptance. A detailed order was passed and the prosecution was directed to explain the situation. However, it has mentioned by the special PP that PW4 Sri Madi, the officer who was in charge of the trap, is not well and the prosecution is not able to give any explanation. Hence, it has further submitted that the court may proceed with the available material. From the above scenario, now the serious doubt has also created in respect of alleged demand. Firstly, there is no conversation on record about such demand. The likely reason of the same is also lying in the admission of the punch witness. There is also possibility that due to the statement of accused about his inability due to the other order of court as admitted by PW1 in paragraph 26, the script as well as voice file of said conversation has not brought on record. Para. It is also necessary to mention here that though both the above memory cards are containing conversation about alleged acceptance of bribe amount, however, duration of one file is 2 minutes 23 seconds, while the duration of other file is 4 minutes 37 seconds. If really there would have been any mistake and same file would have been copied on both memory cards, then the duration of both must have been same. Stop.